Thank you very much, everyone, for attending this session of the ODR Cyberweek 2024. This is the digitization of arbitration for the Greener Arbitrations campaign student panel from Middlesex University here in London. We're very honored to have the students present, and I think the students are very excited to present. We have Jake Barnett, Danisa Ezukuse. We also have, okay, sorry. So one of the students is on his way. Okay. And we also have, so we'll be having Jake, and Jake will be presenting Danisa's part first, and then I'll be introducing Alice, Haritha, and Ade as well once they have to start presenting their presentations. So Jake, the floor is yours.
Hello, my name is Jake Barnett, and I'll be presenting on the validity of digital signatures in arbitration agreements under the International Arbitration Framework. An arbitration agreement is a contract clause where the parties consent for any dispute to be resolved through arbitration. The Campaign for Green Arbitration's Green Protocol for Arbitral Proceedings can be incorporated into an arbitration agreement. This will bind the parties into using electronic documents by default. Parties that are conscious about environmental sustainability may also digitize the arbitration agreement themselves, and so the validity of an electronic signature in an arbitration agreement must be established. To talk briefly about the Campaign for Greener Arbitration, it is an initiative to reduce the environmental impact of international arbitration. The campaign has designed protocols with sustainability measures that parties can adopt in their arbitration agreement, and it largely focuses on digitization to reduce the paper used in arbitration proceedings. The framework for electronic arbitration agreements consists of the New York Convention, which governs the recognition of fluent arbitration awards and arbitration agreements, the Electronic Communications Convention, which ensures that digital signatures have the same legal effect as wet ink signatures, and the Nutri-Trail Model Laws, which provides guidance on electronic signatures and modern communication technologies. Under Article 2 of the New York Convention, contracting states agree to recognize fluent arbitration agreements in writing. Article 2, subsection 2 states that the in-writing requirement consists of arbitration clauses in a contract signed by the parties or arbitration agreements contained in letters or telegrams. The Electronic Communication Agreement under Article 20, subsection 1 states that it applies to the same contracts that the New York Convention applies to, and that for a digital signature to have the same effect as a wet ink signature, two requirements under Article 9 need to be met. That includes that the digital signature identifies the party and indicates their intent, and that the digital signature is reliable under the circumstances. Where an arbitration agreement is being recognized in a contracting state to both conventions and is signed using a digital signature, if that digital signature meets the requirements under Article 9.3, then it would be considered an agreement in writing signed by the parties and would be valid under Article 2, subsection 2. The limitation to this framework is that the Electronic Communication Convention only has 18 contracting states, so there is very little overlap between the conventions, which means there is still uncertainty regarding whether the New York Convention allows for digital signatures when the ECC does not apply. One argument that the New York Convention allows for digital signatures is a purposive interpretation of the convention. The argument is that if the digital signature meets the same purpose as the normal signature requirement, it should be valid. Under Article 2, the purpose of the signature requirement is to identify the parties and ensure their reliability for the agreement to arbitrate. Nutri-Trail suggested a broad interpretation of the in-writing requirement, and the New York Convention also cites their modern technology. A digital signature would indicate the party's intention to arbitrate and would also be reliable due to the encryption. The second argument is the more favorable rights provision found in Article 7 of the New York Convention. This means that the New York Convention does not prevent parties allowing parties to have an agreement or award recognized through the less restrictive domestic laws. So if a contracting state's domestic laws allow for arbitration agreements to be recognized with digital signatures, the party can apply Article 7 and have the agreement recognized through that way. While Article 7 itself does not state arbitration agreements, only stating arbitration awards, Unity Trial suggested applying it to arbitration agreements despite the omission. The second option for an arbitration agreement is that it is contained in letters or telegrams. Unity Trial suggested a non-exhaustive view of interpretation to allow for digital exchanges, and certain case law, such as the Spanish case RJ 2012-6120, has agreed to this interpretation. In conclusion to this part of the presentation, digital signatures may be valid under the New York Convention if the ECC applies, and where it does not, due to the New York Convention citing then modern technology and digital signatures both identifying the parties and being reliable, it should be valid through the purpose of interpretation or through the more favored rights provision. The second part of this presentation deals with the use of trial model laws and digital signatures applicability under that regime. Unity Trial has drafted multiple model laws that states can implement to facilitate uniform adoption for electronic signatures for e-commerce. These are soft law and are not binding unless states choose to implement them and act more like guidance. One example is the 1985 Model Law on International Commercial Arbitration, which was amended in 2006. The amendment allowed for electronic communication to be used for an arbitration agreement if it was accessible for future reference under Article 7, subsection 4. A digital arbitration agreement could be considered electronic communication, and if it is accessible for future reference, it could be valid under this model law as amended. Unity Trial has drafted two specific model laws dealing with electronic signatures. The 1996 Electronic Commerce Model Law, which is considered the blueprint for the ECC, and therefore lays down similar requirements a digital signature must meet to be valid under Article 7, but the ECC does in Article 9. It must identify the parties and be as reliable as possible in the circumstance. However, this reliability test was considered vague, so in 2001, Unity Trial drafted the Model Law on Electronic Signatures and created a checklist for reliability under Article 6, subsection 3. Unity Trial's guide to the 2001 Model Law on Electronic Signatures indicates that encrypted digital signatures would be valid under this framework. To briefly compare with electronic signatures for arbitration awards, the New York Convention Article 3 states that foreign arbitration awards cannot be held to a higher enforcement standard than domestic arbitration awards. The Dallas report indicates that contracting states are moving towards the recognition of awards with digital signatures, and this shift can also be shown with arbitration institutes and their rules allowing arbitrators to sign using electronic signatures. This shift has created more certainty and guidance regarding the use of electronic signatures for awards compared to electronic signatures with foreign arbitration agreements. The overall limitations to this framework consist of the Electronic Communication Convention only having 18 contracting states, which creates uncertainty when it does not apply. The arguments for interpreting the New York Convention in line with the Electronic Communication Convention when it does not apply are based on non-binding Unity Trial recommendations. However, this can be mitigated by how persuasive those recommendations are to the court. Another limitation is that model laws are soft law, and states can choose either to not implement them or have the freedom to change the framework if they choose to implement them. This limitation has been mitigated by the wide adoption of the model laws. However, it should be noted the 1985 model law was adopted mainly before the 2006 amendment. In conclusion, digital signatures are valid for the purposes of New York Convention Article 2, subsection 2, when the ECC applies and its requirements are met. When the ECC does not apply, Unity Trial suggested a broad interpretation of the convention to allow for digital signatures, and Unity Trial has created model laws that act as the framework for the adoption of electronic signatures to be valid for arbitration agreements, but they are soft law unless they are adopted. That concludes my presentation. Thank you for listening.
Thank you very much, Jake. That was very interesting. I shall now pass on the baton to Alice Isong, Haritha Naganaboina, and Adeniyi Adeshina.
All right, thank you very much, Sarah. So I'll be sharing my screen right now. Please let me know if you could see my screen.
Not yet. Oh, yes, we can.
All right, Thank you very much. Okay, so my name is Alice Isong, and myself, Haritha, and Adekanmi will be presenting on the legality of the digitization of international arbitration. Okay, Haritha? Haritha, you're on mute?
Yeah. Hello all.
Okay.
Um, Today we'll be discussing the digitalization of international arbitration and it's a transformative process that modernizes arbitration by incorporating technology. This includes advancements like e-filing, online hearings, and use of artificial intelligence, which are shaping the future of dispute resolution. We will also examine the legal and technical challenges associated with digitalization and explore potential solutions. Let's begin by looking at how digitalization is currently used in international arbitration. Digitalization has brought significant changes to the way arbitration is conducted. The key technologies include e-filing systems, which simplify the submission and management of documents, and online dispute resolution platforms, allowing the parties to conduct hearings remotely, which is particularly useful in international disputes. Artificial intelligence has also emerged as a valuable tool, helping with tasks such as legal research, case analysis, and even drafting procedural orders. These innovations make arbitration more efficient and cost effective by reducing delays and physical resource usage. They also contribute to green arbitration by lowering the environmental impact of paper based and in person process. However, alongside these benefits, there are legal concerns such as cybersecurity risks, where sensitive data may be exposed to breaches, and confidentiality issues arising from the use of unsecured digital communication channels. These challenges highlight the need for robust legal frameworks to support digital arbitration.
Okay, so just as the previous speaker said, Harita, one of the advantages of digitization of international arbitration is green arbitration. So we would ask, what is green arbitration? Green arbitration relates to practices that reduce carbon footprints associated with conducting international arbitration. So examples of these include hard copy filing of notices, documents, letters, or pleadings. We also talk about things like long flights to attend arbitration hearings or to call witnesses to attend the arbitration hearings. And you also talk about delivery of arbitral awards through courier services. So by implication, what this means is if hearings are conducted virtually instead of physically, where you have the both counsels and parties having to fly to the hearing venue, or you have documents and notices filed electronically, this helps to reduce paper consumption and carbon footprint caused by international arbitration. We have a lot of instruments in terms of arbitral institutions and even national laws that provide for virtual hearings, which helps to promote greener arbitration. And a couple of them I'm just going to mention here. We have the UNCITRAL arbitration rules. So Article 7, Article 17, and 28 sub 4 of the UNCITRAL arbitration rules provide for virtual hearings where possible. We also have the London Court of International Arbitration Rules, Article 19, Sub 2. We also have the International Chamber of Commerce, Article 26, Sub 1, and the Dubai International Arbitration Center Rules, Article 20.2 and 26.1, all provide for virtual hearings and e-filing of documents in terms of international arbitration. Now we're going to move on to the legal issues associated with digitization of international arbitration. As we know, as is commonly said, the advantages of things, and for every advantage, most times you have disadvantages. So the fact that we're saying green arbitration to reduce carbon footprint and implement sustainability measures to promote arbitration, if we're saying it's good, it doesn't mean there aren't challenges that people face in terms of digitization of international arbitrations. So we're going to talk about the challenges faced and also recommend solutions to mitigate these challenges or eradicate the challenges completely. Number one, just like Haritha mentioned earlier, we have cybersecurity. Now, the risk has increased with the continuous use of virtual hearings, affecting the security of information exchange during hearings. If the virtual hearing platform is not well secured, the information exchange can be hacked, resulting in confidentiality breach. So, as it is with artificial intelligence or with the digital world as we know it today, we have the problem of cybersecurity. And the issue of cybersecurity is not just a peculiar issue when it comes to international arbitration. Even companies, corporations, organizations, and even countries, they still struggle with cybersecurity issues. So this is a a very serious challenge when it comes to international arbitration, because one of the perks of confidentiality, one of the perks of arbitration, sorry, has to do with privacy and confidentiality. And the moment the documents exchange or the privacy of international arbitration is breached, then it becomes a problem. And because of that, uh, parties are not encouraged, or parties feel discouraged rather, to use international arbitration. The issue of cybersecurity also touches on the second issue of confidentiality. Like I said before, one of the advantages of arbitration is privacy and confidentiality, which leads us to the second issue when it comes to digitization of international arbitration. Now, a Singapore International Dispute Resolution Academy survey showed that 69% of participants regarded confidentiality as essential in choosing arbitration as a dispute mechanism settlement. Now, we know the difference between alternative dispute resolution, arbitration as an example. We know one of the difference between that and litigation is that litigation is done in the open court, it's open to the public, compared to arbitration, which is done in private and which is also confidential. So the moment documents or exchanges or the proceedings of arbitration are hacked, it doesn't become confidential again. That feature of confidentiality is gone. So it's important when it comes to international arbitration, we try to mitigate the issues of cybersecurity risk and confidentiality in order to promote people using international arbitration. Thank you.
Coming to the technical issues and the reliability, which is one of the legal issue. The digital platforms can be vulnerable to hacking, which could compromise sensitive case information or witness testimonies. Similarly, ensuring the confidentiality, as Alice said before, of electronic communications and documents is critical, as breaches can undermine trust in the process. Same as the technical reliability is the major challenge. For example, distributions during virtual hearings, and whether caused by connectivity issues or software malfunctions, can delay proceedings or create procedural unfairness. The lack of global technological standards adds complexity when parties and arbitrators come from regions with differing level of digital readiness. To address these issues, frameworks such as the Singapore Electronic Transactions Act 2010 provide guidance on secure digital practices, while global institutions are working towards consistent standards. However, continued vigilance and adaptation are necessary to keep up with evolving risks.
So, the next legal issue we're going to talk about is procedural fairness when it comes to digitization of international arbitration. As with litigation, which has to do with going to the courts, we have both parties before the judge and they have the opportunity to present their cases before the judge. When it comes to virtual hearings or digitizing international arbitration, we have the problem of using digital platforms. Sometimes we have platforms that are available in a country and are not available in another country. So it's important that the arbitrator or the arbitral institution ensures procedural fairness in digitized arbitration. This has to do with giving all parties equal access to technology and digital tools. This addresses potential biases and technological disparities. So we don't want a situation whereby the arbitral proceedings are going to be done on a particular digital platform or a particular video conferencing platform where it is available in country A and it's not available in country B, or even if it's available in country B, it's very difficult for the certain party to get access to that digital tool. That brings about procedural unfairness, that brings about bias, and it brings about unnecessary stress on the party when this kind of thing happens because it's unbalanced. The UNCITRAL model law on international commercial arbitration underlines the importance of fair and equal treatment of parties. And this should not just be done when the proceedings are physical, where you have the arbitrator in front of you. It should also extend to digital arbitrations. So you have to ensure that whatever digital platform or whatever tools Party A has access to, Party B can easily have access to that same digital tool, just to ensure fairness in terms of international arbitration.
Yeah. Uh, Coming to the cost and accessibility issue, it is another critical aspect of digitalization and arbitration in ensuring inclusivity. While technology enhances accessibility for many, it can also create new barriers. The cost of adopting digital tools, platforms can be prohibitive, particularly for smaller firms or parties from less economically developed regions. High initial investments in digital infrastructure, coupled with the ongoing cost or training and maintenance, can deter participation. Technological disparities further exacerbate the issue. For example, parties from under resourced regions may lack reliable internet or access to the advanced tools, putting them at a disadvantage in arbitration proceedings. These disparities can arise legal concerns, particularly about due process and fairness may be compromised if one party cannot fully participate. To overcome these barriers, solutions such as the cost sharing mechanisms, subsidized access, and training programs can help level up the playing field. Ultimately, the goal is to ensure that digitalization enhances rather it hinders participation in arbitration. Thank you.
Ade, you're on mute.
Okay. All right. Is it clear enough? Can you see my screen, please?
Yes, we can.
Okay, so
Actually, no, we can see a screen. Is it yours?
yes.
Okay.
No, it's my screen. I'm still sharing. This is
Okay.
Ade, can you see my screen?
I really can't though.
You can't see my screen.
No. I can't see your screen actually. Maybe I take it from my own screen. Is it okay?
Okay, so I'll stop sharing and then you can share
Alright,
yours.
please. Thank you. Can you see now?
Not yet.
Is it okay?
Yes.
Okay. All right. So I will be buttressing more on the legal issues and enforceability of arbitral digital awards, digital evidence management, and cross-border legal compliance issues. So introduction, the digitalization of arbitration has introduced legal issues and the enforceability of arbitral digital awards, digital evidence management, cross-border legal compliance. These challenges highlight the need for harmonized legal framework, secure technologies, and international collaboration. So like my colleagues have said, in order to enhance the green arbitration practice, it is essential to, highlight the challenges and, provide solutions to the challenges that faces the whole practice as a whole. So one of the solutions will be harmonizing the legal frameworks, obviously, and then we'll see other ones as we proceed. So legal issues and enforceability of arbitral digital awards, enforceability of arbitral awards. Well, the decision issued electronically by arbitral tribunals. Now, the question is how legal or how legally effective is the decisions being issued electronically? How effective is it being enforced? Now, of course, if we can ascertain that arbitration is an alternative which may suit parties better than litigation, then it is also important to, understand the fact that the awards should be honored even electronically. If the process is done electronically, so how much more the awards? Even though we know challenges that faces it will be, like my colleague said, cybersecurity and all, but of course, there should be some sort of measures to curb cybersecurity and all other factors that may be hindering the electronic process as a whole. So recognition of electronic signature cross-border jurisdiction and compliance with e-signature laws like ancestral model law. Now another question is the validity of the signature, electronic signature across jurisdiction. Now we want to wonder how it will be effective to have an international arbitration and then being honored. And then when it comes to issues of electronic signature, how effective is it supposed to be legally allowed or is it legally enforceable? This project, enhances and encourages such practices to, embrace the act of e-signature and which even the ancestral model law gives room for it. So it's only encourages the process and makes it even more accessible to parties. It also ensures authenticity and integrity of digital issued awards. So the key framework, like we know, like I've said, is the Ancestral Model Law on Arbitration and Electronic Commerce, and also the New York Convention, 1958. So another legal issue in digital evidence management will be, the evidence itself, the digital evidence management itself. And this, helps to secure the reliability and authenticity of evidence. Now, you want to, unlike the litigation process where, litigants, parties bring all sort of evidences to court, it's more accessible without me leaving my country or without parties having to travel so far. This encourages the process of filing evidence and, forwarding the evidence to the arbitration parties themselves and even the judges themselves, arbitrators themselves to to proceed and process the whole matter between parties as a whole, and then recognizing the evidence submitted as legally binding on parties. So, of course, there are challenges to all this. Of course, there are solutions as well. So, one of the challenges is admissibility and validity of digital evidence, which I just talked about. You want to see how effective, how admissible it can be, even though it was transmitted digitally. So, of course, the laws are there that has encouraged the process. And then we have risk of tampering with the cybersecurity threats. This cannot be overemphasized because it's now everywhere. Is cybersecurity issue is not something to toy with because people are out there. There's a lot of people who have interest, especially in the matter being arbitrated upon. So you want to be careful. You want to um, um, introduce every measure to curb every act of cybersecurity threat. Now, further solution will be use of digital platforms for storage and transfers. Now, the evidences that are collected are expected to be secured in a very secure storage facility, not just for accessibility, but of course for future references. In the event that you want to revisit, you want to reopen the file, you have it securely saved in a secure platform. Another one is aligned with international framework like the IBA rules on evidence. That's also important for consideration. Now, cross-border legal compliances issues. The challenges are differing legal standards for electronic signature and data protection, like we have said. So the process, some parties may not have access to this, but of course, with awareness and introduction, that can be solved as well. Variance in recognition and enforcement of arbitral award. Of course, it might be challenging to have you enforcing arbitral awards, especially when it's a cross-border one. You want to, find a very effective way to enforce it. Thereby, questions of where to enforce it, is it the place of the business or the party's jurisdiction? So those are challenges. However, the New York Convention promotes recognition of foreign arbitral awards, which is already enshrined in the New York Convention. So it is actually acceptable by law. Constitutional model law also have guides on arbitral practices globally. So that's encouraging. So recommendations to, solve or provide solutions to some of these challenges will be harmonizing global e-arbitration and e-signatures, which we have talked about. There should be a way to harmonize all this process together such that irrespective of your jurisdiction, you have access to it and it's seamless for anybody to be able to use. Establish secure digital platforms for evidence and communication, also very important. Promote training for stakeholders in managing digital arbitration. Now, this is very important, especially for lawyers. Some lawyers are not digital or electronically inclined, so you want to provide training such that once these applications or softwares are being introduced, it will be useful to everybody and accessible to everybody at the same time. Then lastly, foster interjurisdictional collaboration for uniform enforcement. Now, jurisdictions have their different enforcement procedures, but which may become a challenge for enforceability, especially when it's cross-border. If you have to go to another jurisdiction to enforce your arbitral award, it may be challenging. But because of the law, I mean the lay down laws for enforcement processes. Now, if we have a central one which is being introduced globally, it will be easy for everybody to enforce arbitral awards. So, in conclusion, the digitization of arbitral enhances efficiency but introduces legal challenges. Our key focus area is enforceability of digital award, digital evidence management, cross-border compliance, like I've said. So we have talked about harmonizing legal frameworks to secure the process itself, and then technologies are critical to solving these issues. So generally speaking, it's a very good project, and it's encouraging to have this system incorporated even globally, such that the arbitral system, its international arbitral system, will be seamless and enforceable by every party without having to stress or go through the litigation, like the main purpose of arbitration. Thank you very much.
Thank you very much, Ade. That was really excellent. Not that I'm biased or anything, but I'm very proud of you. So thank you very much for the excellent presentations.
Thank you.
So Jake, Alice, Haritha, Ade, and of course Danisa, who couldn't be here unfortunately. Thank you so much for all of your work. Just to also say, obviously, this will be published in the form of a report. We'll be publishing it on the website of the Greener Arbitrations campaign, which is an international campaign, as you can tell, that focuses on partly the digitization of international arbitration. So thank you very much, everyone. I'll open up the floor for any questions, if there's any.
I did have a question, if you don't mind.
Thank you very much, Daniel. Go ahead.
Yeah. Are there conditions under which you would suggest that technology not be used for arbitration? In other words, are there conditions when you would say to the parties, no, we need to travel and be in the same room together?
You can take turns if you want to answer.
Can you come again with the question, please?
Yes, we've been talking about the use of technology of various kinds to do arbitration.
Yeah.
And that's very common now to use, sometimes not doing the entire arbitration session online, but for using technology to do at least some of the major functions that you do in an arbitral situation. Are there situations that you can envision where you would say to the parties, we should not use technology at all. We should get together in a room and exchange documents by paper. Is there any situation where you would recommend that to the parties?
Yes, of course. Where for me, I feel where the matter is of high confidentiality and there is threat to an invasion on the evidences to be filed and other vital aspect of the whole process, then it might be very important to set aside the electronic use of certain apps and all that. It will be if parties think it will not be in the interest of justice, then of course it is good to set aside the electronic process and proceed unelectronically, so to speak. I don't know if that answers you.
Alice?
One of the things that I recommend for mediators and arbitrators and other dispute resolvers is what I call a risk damage assessment. Talk to the parties about the kind of information they're going to be exchanging and what is the damage that would be done if that information were seen by people who are not supposed to see it. And then look at the risk of the technology that you're thinking about using for that information to be compromised. And I'll just use email as an example. I would never use email for confidential information of any kind, because I'm sure probably everybody here has either gotten an email that wasn't intended for them or has sent one to somebody they didn't mean to send it to. It's very easy to misuse it. So if the damage would be high, I look at the technology and the risk that the technology gives, either in misuse or by hacking or whatever, and try to make a decision about what to recommend to the parties based on that. So I think your answer is right on the money. Thank you. And thank all of you, by the way, for the panel. It was very good.
Thank you.
And really delighted to hear all the things that you had to say.
Thank you very much, Daniel and Ade. I think Alice wanted to also share her 2 cents on.
Yes. What I wanted to say was very similar to what Daniel just said. But I'll also add something. I don't know, it might not be something, it might not be so much. I'm also thinking in line of that some cases that I feel are not just about being sensitive, but are emotional, that it's better to have the parties face to face, physically. And I think one example I'll use is marital proceedings. Okay. So when you think of marital proceedings and probably using arbitration or mediation, any form of alternative dispute resolution to settle marital proceedings, I mean, it's okay to do digitally, but then when you talk about the physical presence of both parties, you're thinking of trying to bring the parties together, and there's a difference when parties are there physically and conversing, and you're trying to mediate or arbitrate the divorce settlement or whatever it is. But at the same time, you also want to try to bring the parties together so that they don't, get divorced at the end of the day. So there's a difference when it's physical and you're seeing the whole emotions, and just seeing your husband in front of you, or your partner, your wife, whoever it is in front of you, that tendency to have the issues resolved physically than digitally is also there. So there's some cases, apart from sensitive matters being shared, but there are also some cases that I would recommend physical, depending on what's it called, the location of parties. I mean, if they're within the same area or something, I mean, it's something you could recommend physical settlement of dispute, arbitration or mediation, whatever alternative dispute resolution you're using, because it would have more effects than sitting over the phone and just talking back and forth at each other. So that's just what I wanted to add also. Thank you.
The only thing that I would say about that is I totally agree with you. The one exception I would say is that one of the things that I think the use of technology in arbitration and mediation is really good for is reducing the sense of risk that the parties feel. So if there were a mediation or an arbitration where there was a history of abuse on one side or the other, or whether
Yeah.
one
Yes.
parties felt that it was unsafe to be there, then
Yes. Yeah.
use the technology to take away that feeling of fear.
Definitely. Yes. True. I agree.
Yes,
Fabulous panel. Thank you so much for your research and for putting it together and just spending time sharing it with us. I have a couple of thoughts and a couple of questions. One is, I was struck, many of us have been in conversation for a while about some of the benefits, especially convenience, and also being able to, the convenience of digitalizing, and also the ability to manage more data, more issues more quickly, for example. You touched upon that, and also some of the risks, confidentiality, bias, et cetera. You touched upon that, very helpful. But I want to note that I don't recall many of us in the field making suggestions about how to decrease the imbalance of power. And you have done that beautifully. So I want to compliment you on that and also invite you to consider more work on that. And if you do more work on that, to present on it, to consider publishing on that. So I'll just point out a couple of things that really stuck out to me, and welcome if you want to speak more about this. But I think Adi Comics, you mentioned the idea of of training. Once there's harmonization, and then to train people to be able to know how to apply that accurately. I don't think we've had enough discussion about that. We've discussed and debated in the field about the need for harmonization, but that's just really a cutting edge topic that you're bringing to the table. And in the presentation, Alison, Haritha, that you mentioned was also the idea of subsidizing if one party can't access because of money a platform that it becomes critical or becomes most common, then you're making a proposal about how the costs could be shared in a way that could make that possible. So anyway, I just want to compliment you on that and also say I think this is an area of the field we need more discussion on. And so if I could also then ask a question here about the fact that you're part of this green movement, which we need so much, of looking at the value of not flying to see each other. And when we can to use digitalization or video conferencing. But I also know that when we apply AI, which is in growing importance in digitalization, that it sucks up a tremendous amount of energy. So I wondered if you had thoughts, especially as the next generation that's dealing with climate change in a way that those of us who are older won't even have to deal with. What are your thoughts about that tension between us not traveling to see each other so often so that we can save emissions, help save the planet, and also the AI sucking energy? And I invite Jake into the mix too, because your presentation started us off so well about the benefits of digitalization.
Okay, for me, I think, well, that's very important for me. I would rather have the meeting over the phone than having to travel all the way. That saves a lot of time, saves the energy and all that. And then at least, I mean, Daniel mentioned something. You want to avoid confrontation because at the end of the day, you don't know the other party's intention. You don't even know the agenda. You could be dealing, we are talking about international businesses, yeah, big businesses involving different kind of people, cartel and all that. So you want to, avoid such things. And well, if you have to wait on a scale, I think it would rather be getting acquainted with the use of the AI for me, rather than having to travel. Because if you have to travel, you'll be missing a lot. Imagine me going to China. I would rather stay and do a lot of more businesses right here. If I have to travel to China to attend an arbitral process for a week, that might be taking a whole lot from me. Apart from the expenses, the time also. Time is money, and then you might be losing out. So if you have to wait for me, I think I would rather the use of AI, to be honest.
Yeah, like I have a thought that even AI use is like it based on the person who is using the AI. Like AI doesn't have its own point of view of what it is dealing with it. Like what we input to the AI, that only it generates the more information and elaborate our situation in a different way. That's the AI do actually. And I prefer like digitalization itself because as it is cost effective and we don't need to travel anywhere or the time consumption, it everything is reduced in digitalization. But coming to the confidentiality, through secure channels, it will always be confidential, like many of the organizations do it. So digitalization is like the future actually. But considering the gravity of the situation or the circumstances, it can also be lead to in-person procedures, while many of the parties want in-person procedures to see each other, or they need the mankind to themselves to know how they are reacting to us. As in digitalization, it cannot be seen. So it's like my point of view about this.
Thank you very much. Haritha, that was actually very interesting. Yeah. Are there any other questions from the attendees? Thank you so much, Mary, for your very kind message. So Mary's saying thanks a lot. Thanks for all the presentations, reflections, and learning today. Congratulations to all the speakers. And I would like to invite everyone to congratulate the speakers. Thank you so much, everyone, for the presentation. And obviously, thank you so much, Leah, Daniel, for being part of the organizational panel for this wonderful conference. We are very thankful, delighted to be here, and obviously to the rest of the organizational team as well. Thank you very much for inviting us to present, and we look forward to April for the ODR forum, which I'll talk to you guys about.
Wonderful. And I want to encourage all of you as you go forward in your careers to consider submitting articles for the International Journal for online dispute resolution while you're a student or after you complete your degree. And Daniel is the editor of that, so you can be in touch with us if you'd like to consider submitting something. It would be fabulous to get your points of view in publication. Thank you, Sara, for bringing this all together.
Thank you.
Yes, let me add my thank you as well. And one of the things that both Leah and I have talked about for years is the fact that a lot of the people who are dealing with online dispute resolution and technology and dispute resolution look a little bit like me. They've got gray hair and they've been around for a while. And it's really, really good for us to know that there are people who are coming along behind us who are going to push this field forward and maybe undo some of the mistakes we've made and maybe make some of your own, maybe. But move the field forward, and we feel like it's going to be in very good hands. We really appreciate you.
Thank you very much, Daniel. Actually, that's we're very honored to hear that from you and Leah. And we're just very, very pleased. Thank you so much, Deborah, as well, to your message. And thank you so much again to Jaya. It's nice to see you. I know we've seen each other in Williamsburg last time, so hopefully maybe we'll meet up soon again. Well, thank you very much, everyone.
Well,